All right, well, good morning, everyone. My name is Scott Mozingo. I'm with First Guardian Title, and I've been with First Guardian Title for about 3 weeks now, but I've been doing this for about 25 years. So I started in 2001. The thing I find interesting right now is the interest rates are about where they were when I first started in the business. The only difference is when they were at 7% and I bought my first house in 2001, everybody was excited to have 7% because it had come down from 7.5%. So now we're seeing those interest rates, they've come up instead of going down. But we're kind of in that same spot, and I think interest rates are, historically still pretty good. And we'll see the, interest rates kind of fluctuate, but it seems like they've leveled off a little bit right now, and so the home buyers and sellers have kind of leveled off. But I've been around long enough to see the fluctuations. So I saw the booms in the early 2000s, and then went through the mortgage meltdown and a lot of short sales and foreclosures, and then the recovery from that. So just a little bit of background about myself. I'm originally from Northern Virginia, grew up in Manassas, currently live in Manassas, kind of lived a couple different places around through undergraduate and law school, and have worked my way back to where I live about 3 miles from the house I grew up in. So not too far. So definitely Prince William County in Northern Virginia person. Went to undergrad in North Carolina, and then came back to go to law school at George Mason. So definitely in the area for most of my life, and in the Northern Virginia and Prince William County areas. So as far as teaching and talking, we're going to go through some questions we've got here. We're going to go through our website and some agent tools that we have. I've been teaching since 2001. I started with PWAR, Prince William Association of Realtors, in 2001, teaching with them. And then I've taught classes for NVAR, I've taught classes for DAR, for FAR, for GCAR. So I've been all around. Yeah, all the ARs. Yes, I've covered all of the ARs. So we've definitely, I've definitely made the rounds around Virginia. Teaching classes. And then at First Guardian, we are in the process. I'm setting up our school, so we'll have our own school and our own classes available. I brought some list of the classes that we're going to have available, and we'll have all that stuff up on our website as well. And I think we already have some of that information up there on some of the classes that will be offered. We've just got to wait for DPOR to meet and get some of that stuff approved. And so hopefully the middle of May, we'll have some classes ready to go for you guys. And we'll be offering stuff online. We'll be offering in-person stuff. Today we're here at People's Mortgage. And so, we'll be doing some stuff out and about in the community as well to teach classes. So I guess if you guys have any questions, if you want to start with that, or I can go into the website, whatever you prefer.
Yeah, we can get some questions going here for you.
You said you're in Manassas. Does First Guardian have an office in Manassas?
They do. That we actually have a little satellite office that's my own setup right there in Old Town. So if you are in Old Town Manassas and you want to have your closing there, or if you just want to stop by and grab lunch, there's plenty of restaurants within walking distance of the office there. So feel free to come by and see me.
Where did you go to North Carolina?
So I went to a little school called University of North Carolina at Pembroke.
Pembroke.
Yes. So when I was there, it was actually called Pembroke State. I was actually the last class to graduate from there under the name Pembroke State. They changed it to University of North Carolina the year after I graduated.
Oh, that's cool.
So in fact, my diploma, they asked us if we wanted the University of North Carolina Pembroke diploma or the Pembroke State, and I said, no, I graduated from Pembroke State. I just want the Pembroke State diploma.
Nice.
So small little town. Basically, if you go down 95 until you get to about exit 17, right before you get to south of the border. Then you go west for about 10 miles through cornfields, soybean fields, collard green fields. And then there's this little town. I was telling Brooke earlier that we had, my first year there was a Hardee's in town. That was it. By the time I left, there was a Pizza Hut and a Subway. Nice. So definitely a very small little town. So.
When you got out of law school, is title the law that you practiced right away, or did you practice anything else? I'm curious.
Yeah, so I actually, the whole time I was in law school, I worked for an attorney that did juvenile and domestic relations and some criminal
Oh, what fun.
stuff. Yeah. Well, and the first attorney that I worked for, she actually became a judge in the juvenile court. And so then when she did that, I went and worked for another law firm and did criminal and domestic relations. And I always tell people I didn't mind the criminals because you were kind of their last hope, their best friend, you know. Didn't even mind the jail visits, as weird as that might sound. The people getting divorced, that was a different situation. You know, you would find that even your own clients weren't honest with you in those situations. But yeah, so criminal I didn't mind. But I just got to thinking, you know, there's so much kind of, opposition in those fields, and nobody was ever happy. You know, if you were representing somebody getting divorced, they were never happy at the end. And the criminal, you know, they might be happy, but maybe not. And so I had an attorney that was looking for somebody to come run a title office in Woodbridge. And so I ended up going to Woodbridge. I figured real estate, usually there's a seller that's happy, there's a buyer that's happy. You know, they wanted to buy, they wanted to sell. Now that's not always the case.
Unless the sellers are getting divorced, right?
Yes, yeah. Yeah, and I've had plenty of those as well, where the seller is getting divorced. We usually try to put them in different rooms or have them come in at different times. Some of the more uncomfortable settlements are the ones where you have the divorcing couple, especially when we used to have settlements with everybody there at the same time. Oh, yeah. And you had the divorcing couple on one side, and usually it always seemed to happen that the buyer then was like the young couple that just got married like 3 months earlier. And they're just like staring at this couple that wants to kill each other right across the table. And so we tried to get the sellers out of the room fast in those situations. So good question. I did do domestic relations. I did criminal work. Actually, one of the cases that I was hired on for that law firm, they were doing a capital murder case trial that they had going on there. And that law firm, actually, after I left, they went on to represent one of the snipers. If you remember the snipers that we had to deal with there for a while. Wow. So I wasn't involved in that. I'd already left at that point. I was happily doing real estate at that point. But yeah, that was all 2000. That was about 98 when I was in law school, all the way up through 2001, 2002.
Now title.
What
do you like most about being an attorney and running a title company?
Well, I still think one of my favorite things to do is a first-time homebuyer closing, because they're usually so excited. They have so many good questions. I mean, one of the things that I've done for my 20-some years doing this is education. And so I really do education even at the table. And so I always my goal really is that the buyer or seller don't need to call me with questions the next day, because I answered the questions when they were, when they were there at the table. So I really enjoy kind of that first-time home buyers. Not to mean I don't enjoy the other ones. I mean, but sometimes, especially we live in a very transient area where you have military people moving in and out, and it's like their 8th time buying a house, and they're like, I don't want to hear anything about any of the paperwork. Just tell me where to sign, and let's move on. In fact, I had one last week, and the guy's like, I think my goal is to try to set the record for your fastest seller signing.
Wow.
He was basically saying, I know what we're doing here. I've already looked through the numbers because your staff already got me everything. Just show me where to sign and let's get through this thing. Very nice guy, but he was not interested in hearing a whole lot of stories. So it is a little more fun, I think, with those home buyers where you can have those conversations with them.
Yeah, I agree. And I know that in the title aspect, you're normally present. You're always expected to be present because obviously, you're the ones going over the paperwork and everything, but lenders don't really have that obligation to be at closing. But
right.
I love going to first-time buyer closings.
Yeah, they're always so excited.
It's just a different energy.
Yeah, I mean, I've had times where people are crying at the table.
I know.
Sometimes you have the sellers crying. That's different. But for the buyers to be crying at the table,
joyful.
Yeah. And one I had, this was about 10, 11 years ago. And it was a guy who had, gone through a lot of struggles in his life. I came to find out through the agent later on. But he had built his life back up and had, he was in his 40s, but buying his first house. And when we got done, he just broke down crying at the table. So it was really cool, really cool settlement. So
that gives you a lot of purpose.
So that's one of the reasons why I like the education part too, because not just the buyers and sellers, but the agents as well. I like to talk to, especially I used to teach some classes at DAR for brand new agents that were getting their post-licensing credit. And those were always cool because they didn't, they knew very little other than what came through the Mosley books or, their pre-licensing type of classes. And so it was just like they were just a sponge where it was just like filling them with all the information. So those classes were really cool too, talking to brand new agents and getting them up to speed.
Yeah, but going off on the agents and what you, through your experience, have seen, what steps do you recommend agents take to ensure a smooth closing process from the title perspective?
Yeah, I mean, I think that if you don't do anything else, the one thing to do is communicate, right? So many new agents are afraid to get involved in the, kind of the buyer's lending process. They're like, oh, that's for the loan officer to do, and they kind of step back. Or, on the seller side, they list it, and then they get a contract, and then they're like, well, everything from here on out is the buyer and the lender, and they're not really involved in it. And so I think if you just communicate with your client on a regular basis, one, you're not going to have as many complaints because they're going to know what's going on through that process. But you're just staying on top of it. If you're on the listing side, you're calling the buyer's agent and you're calling the lender and saying, hey, where are we? We approved? Has the appraisal been done? And going through that. So really just communicating and we live in such a world where you're tied to your phone and everybody's texting and everybody's, sending messages, emails and things like that. And so sometimes just picking up the phone for a new agent is such a key. So many agents are like, well, I don't want to bother the other agent or I don't want to bother the other party. But, just having that communication. And a lot of times it cuts off problems before they become problems. Because I hear a lot of times agents complain about the other agent. And it's like, well, if they just had a conversation early on, they probably would have gotten ahead of this and it wouldn't have been an issue.
Right.
So I just think it's so important that communication for the agents and the agent community, I've been doing this long enough that I found it's very small, right? All the agents know other agents.
Right.
And so if you aren't communicating, if you're not returning phone calls, if you're not returning texts from the other side, agents remember that. And they remember that when they get another offer in from you at some point in the future. So I just think it's so important to have that, that communication with your clients, with the other side. It makes everything run so smoothly. And that way you're always on top of it because you've been talking about the process, you've been going through. And then, the other thing, of course, is just have, a checklist of your deadlines of, things coming up. Because the buyer and sellers, even for somebody that moves a lot, like a military home buyer, that's maybe moved 8 times. That's it, right? Like for most of your clients, they've moved once or twice in their life, maybe 3 times, bought a house. But you as an agent, you've done this dozens of times. For some agents, hundreds of times. I've been through this thousands of times at this point, probably tens of thousands at this point. And so, you really want to make sure that you're educating that buyer, that seller, because they are relying on you, the agent, to bring that information to them.
I have a question. My last closing, we actually had this come up. The seller purchased the home back in October of 2024, and the previous seller, I guess they redid the plat and everything, and they found out that the legal description was incorrect. However, it wasn't corrected at their closing. So here we come to our closing, and now we can't close because the seller before the seller needed to sign off on the paperwork and the changes, and he is out now. He's a over-the-road truck driver and can't come back, and he only wants to do a wet signature.
Okay.
So how could that have been avoided or caught? And he closed with an attorney out in Richmond. So I feel like that was something that probably should have been identified at the time of his closing, especially since he had an attorney. The seller now had an attorney when he was buying. So how could that have been avoided?
Well, I think your instincts are right that maybe at that first settlement, maybe a little more attention should have been paid to the paperwork and showing that property that was being that legal description that was created, and then passed on to the new client. But you would be surprised how many times, that is a legal description that's incorrect is not an uncommon title problem. Now, a lot of it comes down to how incorrect is it, right? If, it's just kind of a typographical error, because a lot of times it'll tell you the lot number and the section number and the subdivision, and then, down further it'll tell you like where that plat's recorded at.
Yeah.
And it's not unusual for you to have typos in there. And that we can really correct on the deed, and we don't necessarily need to get the previous owner involved, anything like that. But to have a problem like yours, where you have a previous owner that now needs to sign a deed of correction or a deed of confirmation, unfortunately, if you get past that first one and you don't catch it there, and you catch it at the next one, that's kind of the only way to fix it.
Okay.
Now, depending on what the issue was, the buyer's title insurance probably would have covered them for the issue, assuming that they bought title insurance, which they should be buying title insurance. But if they bought title insurance, probably would have covered them, but then you've still got to correct the problem so that new buyer has new title. And that's really what the title company, that's kind of what we're supposed to be doing, right? Is clearing title, making sure that the title is clear for that new buyer so that when they go to sell the property, they don't have the issue. And so they might have had some coverage under that title policy, but it sounds like that for your buyer, that title company was able to step in, find the seller. I mean, luckily the seller was still around and willing to sign. Sometimes you run into problems where sellers don't want to sign, or maybe they're not around anymore. They could have passed on, and you maybe have an estate or something that you've got to deal with. So at least he was around. I mean, it would have been nice if he was willing to do the remote online notarization, and maybe you could have had the deed done while he was, in Texas or wherever he was trucking around the country. But there are options, if somebody is traveling around the country, you can do the remote online notarization. You can do a remote notary a lot of times. We can have a notary go meet with them for them to sign. So there are some options to kind of track people down. But yeah, I think, going back to your question, I think the best thing would have been to catch it at the first time. But once you see it that second time, now the good thing is they've caught it, they fixed it. Now your buyer's not going to have the issue. And so a lot of times when I do have a title issue that comes up, typically depending on the issue, we call the seller first to let them know what the issue is. And depending on how serious it is, we might go back to the buyer and say, hey, this is the title issue, but we're working to take care of it. And I always like to explain what it is to the buyer and that we are going to take care of it, right? So that they don't have to worry about it. And provide them with paperwork that shows what we did to take care of it. So so we're always trying to make sure that buyer, when you really get down to what we do, that's what we're supposed to be doing, is clearing title for that settlement. Yeah.
I've noticed a lot of people now that are sellers are selling from an estate. And can you talk a little bit more about when people pass and the property, whether they die with a will or without a will?
Yeah. So just so you know, I have a 2-hour class that we're getting approved called Death, Divorce, and Bankruptcy. About the first hour of it is on death. So I could go on and on this topic. This is one of my one of the classes that I get the highest attendance at is this one, and another one on wills and trusts, because we're all going to have to deal with it at some point, right? And in fact, in those classes, I tend to get a lot of questions from the agents, not even necessarily about their work questions, but about their own personal life, what they've got going on. But yeah, going back to the estate, I think we're right now, because a lot of sellers, let's be honest, they have interest rate at 2.5–3%, so they're not looking to sell. And so I have found a higher proportion of our sellers right now are either divorces or death. And so there's a couple different ways that can be handled. One of the easiest ways is if they had survivorship in the deed. And this is one of the things I always talk with new buyers about and make sure that they understand survivorship. Whether they are a married couple taking title as what's called tenants by the entirety, or they are joint tenants with right of survivorship. If one of them passes, property automatically passes the other one. They don't have to record a will. They don't have to probate anything. They just have to provide a copy of the death certificate so we know the person's deceased, and then they can sell the house. But if you don't have that survivorship, that's where you get into the will, that's where you get into the estate. And of course, it's better if they have a will, because if you don't have a will, now you've got heirs that may or may not get along, and they've got to decide on how they're handling the property. And if you're the agent, now you got to find out, do I have all of the heirs? And I've got to get them all to sign off on the listing agreement, get them all to sign off on the contract, get them all to sign at closing. And it's probably not bad if it's a brother and sister and that's it. But inevitably there's like 6 or 7 of them.
They all surface when this stuff happens.
Yes,
That, or I've seen where 2 of them are passed, and now you've got to find their heirs.
Yes.
So if there's a chain involved.
Yeah.
So this is what I guess you guys have to do, don't you?
Yeah. And I had one. This was about 5 or 6 years ago, and we had 2 sisters that were selling Dad's property, and Dad had passed, no will. They said they were the only heirs. They had filed the paperwork at the courthouse saying they were the only heirs. They had signed affidavits and had people sign affidavits saying they were the only heirs. And a couple months after settlement, come to find out Dad had a son from different relationship that nobody knew about. But that son then saw that the property had been sold. And so now you're talking about a title problem. And one thing I always tell buyers is title insurance is important. But if you're buying from an estate, this is almost required, right? Because you never know if somebody that passed away had other children from another marriage, another relationship, whatever. There could be all kinds of things that play into that. And so you want to make sure you have title insurance. So the buyers were covered under the title insurance, and we got involved with the sisters and the brother and, introduced everybody, as awkward as that might have been. And they were able to get it resolved. There's all kinds of things like that can creep up in an estate, and that is why it is the kind of the riskiest time to insure title to a property for a title insurance underwriter, is because you do have a time period where any creditors, any other siblings that want to make claims against the estate can do that. And so, that buyer is going to want title insurance, and if it's only been a year since the person is deceased, that seller is going to be required, and this is in the contract. It's hidden. It's in the title paragraph that nobody reads because there's no lines and it doesn't really need to be filled in. But in there it says that the seller is to provide good title to the buyer and good marketable title, insurable title, and that without the need for extra hazardous risk premium. And so if the person is deceased and it's not a survivorship, so it's an estate, then what's going to happen is that seller does have to pay an extra risk premium on the title policy for the buyer. So not super expensive. Now, they actually don't have to. They could wait a year, let us hold the money for a year, and then get their funds. But nobody wants to do that, right? You're getting $100,000 from selling mom's house. You don't want to wait 11 months to do that.
Right.
Now, if mom died 11 and a half years ago, and now it's, or 11 and a half months ago, and it's only, a couple of weeks until that year would be up, then maybe you wait and have us hold the money for 2 weeks, and then we do a title bring down, make sure nobody challenged the estate, and then we can release the funds. But outside of that, the extra risk premium is typically what most people will do.
Is that like a costly fee? Or
it's not. It's typically based on depending on the underwriter, it's typically $2 per thousand. I think the minimum is like $250. And our average sales price, you're probably talking $500 to $700. For a lot of people, when you're selling, mom's house and mom and dad lived there for 40 years, and you're getting $400,000, it's probably worth spending $500 to get $400,000 as opposed to waiting 10 months to get that money. And a lot of times people think, oh, my kids, they won't sell my house that fast, right? But you typically do.
Yeah, they do. Yeah.
Because, and it's not so much like a sentimental thing as much as, do they want to carry the insurance? And if there's a mortgage, carry that. And if, upkeep on the house. And it's a lot of work. And so typically, when somebody does pass, the house is going to be sold within like 6 months. People just don't, unless one of the kids already lives there and wants to maybe live in it at some point. But very rarely does that happen. Mostly they're selling the house. So this is also when you find out the kids that have trouble with their finances, because we do a judgment search against them as well, because they are technically an owner of the property. And if one of those kids has a judgment against them, it's going to attach to the property, and hopefully the judgment is for less money than what they're getting out of their cut. Because if it's not, then it could cause problems with the other siblings, for sure. For sure. Yeah.
What advice can you tell us agents to, when we're actually, because I'm seeing a lot of it, what advice can you give us to ask for ahead of time for them to be prepared for?
For an estate or?
Correct.
Yeah. So
like mom and dad passed away. What do and the kids are selling the house. What do you guys need?
Yeah. So the first thing is I tell agents, ask a couple of questions before you even list the house. Because typically people don't quite understand how the titles and the documents all flow together. So people will call you a lot of times and say, hey, I have power of attorney for mom. One of your first questions should be, is mom still alive? Because the power of attorney is only good if she's still alive. And if she's deceased, then the power of attorney is no good. But more than likely, a lot of times when people do their estate planning, the power of attorney, the executor on their will, the trustee of their trust, typically they name the same kid. You know, the older, most responsible, or maybe not the older one, but the most responsible kid is usually the one that gets the penalty of being the one to take care of mom and dad's estate. And so you want to ask, kind of dig a little bit to find out what capacity. So if they say power of attorney, but mom's dead, no power of attorney, but they probably are the executor. So then find out, are the executor? Did mom have a will? So that's really the first thing, is find out how they're coming at you with this. You know, was there a will? Do they have the original will? Because if they don't have the original will, they can have a copy, but it's not going to be recorded at the courthouse. It's the same as not having a will. So they got to have the original. So ask those questions. I usually tell agents too, and that's probably the most frequent phone call I get, is call me. My cell phone number has been my cell phone number for as long as I've had a cell phone. And so I have agents that call me all the time, and that's probably the most frequent call I get is, I'm getting ready to take a listing, mom passed away, meeting with the kids, what should I ask them? And if you give me the property address, I can do a little bit of kind of preliminary digging too. I can look at the tax records, see if they've recorded a will at the courthouse already, see if they've recorded, a list of heirs or something like that. So we can do, kind of digging in the tax records and in the land records and see if we can give you some preliminary information so that you can go in informed for that listing agreement. So I think that is important to have some of that information as you go in to meet with them.
I do have a question. This is something that I've experienced too in a few deals about the probate. Mm-hmm. Can you elaborate more on that and how it can be also, I guess, more time efficient? Because I know that you're telling the agents you got to ask the questions, but sometimes I think that they don't know when to ask the question, because it could just seem like a pretty normal situation where someone is talking to them and saying, hey, I want to list this house. Yep.
Yeah. And that does happen where people say, hey, I'm the owner of the house, I want to list the house. And then you go meet with them at the house, and so you don't think anything's weird. And, the first thing I would say is obviously check, in the MLS to see who's listed as the owner there. But even that, MLS pulls from the tax records, which pulls from the land records. Mm-hmm. So there is some translation to get between there as well. So that's not always 100% accurate, especially if something has just been recorded, like the will just got probated or the list of heirs just got filed. That could take weeks before that is showing up on the tax records and on the MLS. So, you do want to ask some questions. One of the easiest things to do is just ask, hey, when did you buy the house? And if the answer is, oh, I didn't, my mom bought it, well, then we've got an estate probably that we're dealing with here. And so, and people a lot of times think that they just own it, right? Because they met with an estate attorney who told them, well, mom left it to you in the will, so you are the owner. And that is true when you get to kind of the law school answer to the question portion of it. But when we get to the real world, what you need to do, it is a little bit different. And so there is some stuff that has to be recorded at the courthouse so we can show kind of the chain of title and how we got there. And so I think just kind of paying attention to that as an agent and, doing a little bit of work before you go to meet with them to list the house, whether it's just looking at, at the tax records, asking some questions about when did they buy the property, how much they bought it for. These are all legitimate questions anyway, even if it's not an estate, because, you want to know, are they dealing with some capital gains or, how much gain are they looking for in this house? So I think that's a good way to kind of start the process is that. But if they have any questions, just call.
Right. Yeah. I mean, we had some deals where we got to find out that we needed a probate.
Yeah, I think.
Done like a week before the
yeah.
closing date, and I was like, oh,
Yeah, and depending on the county, I mean, people get so scared. Like the word probate is this like boogeyman, right? Like very scary thing. It's really just an office at the courthouse, and you just have to record stuff there. And depending on the courthouse and how busy they are, you might be able to get an appointment tomorrow to record there, and you might be able to get an appointment 2 weeks from now. So that kind of depends. I mean, I've had settlements where people have died after signing the contract, and so now you have now you've got to probate before you can get to settlement. And settlement might get delayed in that instance, but once they probate the will or once they file the stuff at the courthouse in the probate office, we can typically go to settlement right away after that. We just have to have proof that it was recorded at the courthouse. We just do a bring down from the courthouse to see that those documents are there. We're not looking, it's not like they are filing a lawsuit and it's going to be a 6-month wait, right? It's just filing that necessary paperwork at the courthouse typically is all that it takes, and can typically be remedied in a couple weeks and maybe even sooner, depending on, did mom leave the will where they could find it, or now are they hunting through the house and throwing things away and trying to figure out what they threw away and where that is. So.
I know you said that you were going to talk about wills and probate and all of that in another class that you said that you would be teaching. But would you advise an agent if, in fact, Mr. Jones doesn't have a will and he's not married? But he's got a kid? Would you advise him to give power of attorney to the kid? No, you can't, because then it's dead. What would you advise someone that if they are? It may not make it to closing.
Yeah, no, and I do have this conversation. It's always a little bit weird, right? When somebody's buying a house, it's like this happy occasion.
Yeah.
And I get to the deed, and I always have a conversation with the buyers at the table about the deed. And it involves death, and it's like, what a sad, terrible thing to talk about. We're popping champagne bottles and moving into the house. What are you talking about death? But that's the time to figure it out, right? And so if it's the married couple, that's fine. If one of them passes, the property automatically passes the other one. I always point that out to them. I go through that. But some of the sadder estates that I've had to deal with is you have like the young kid that bought the house at 25 and then passed away at 27. And now mom and dad are trying to figure, well, at 27, most people don't think about a will or a trust. That's the last thing they think about, right? And so I typically will have those conversations, though, with that like young home buyer that says, hey, if you really care about your parents, have a will in place. It could be a 3-page will that just says, I leave everything to mom and dad. That's it. That's all that you need for this, right? It doesn't have to be complicated. And you'll make mom and dad's life so much easier. And there are other vehicles for doing this, too. You can do a trust, which, we love on the title side because it makes the closing and the title work and kind of the preparation leading up to it a lot easier. Because with the trust, the trust is still kind of the ownership is in the trust, and it's just a new trustee that owns the property, the successor trustee. There is also a document called a transfer on death deed, which is, that's a law, I'm trying to think, 2013, 2014, I think, that Virginia passed. So it's not something, when you talk real estate, real estate in Virginia, we're a very old state, goes back to, the king. This is, something that was just passed within the last 10, 12 years. But it really is a way to get that property to who you want to get that property to without maybe going through the expense of setting up a big trust. But if your only asset is maybe the house, right? You've got that young 25-year-old kid, and they don't have a whole lot of other assets at this point. Maybe you do a transfer on death deed that says that if I pass away, property goes to my parents. So I do have that conversation with, anytime it's a sole buyer, I always say, you want to have a will in place at a minimum, so that everybody knows how to handle this if this were to happen. For a lot of our buyers, it's co-buyers, so they're either a husband and wife, or they are the young couple that's not married, but they are taking as joint tenants of survivorship. And then, since as long as only one of them passes away, you still have the survivor that's there. Now, if both of them pass away, then they still do want to have the will. So I still do recommend that, but they might not necessarily need it. Yeah.
As a real estate agent, what are the biggest liability risks for realtors, and how can I mitigate them?
So I think one of the things is just the deadlines and the timelines that are in the contract, right? paying attention to those. Ultimately, the agent's not the one that signed the contract. It's the buyer, it's the seller. It's the buyer's responsibility to do this, the seller's responsibility to do that, right? But they're relying on you as the agent.
Right.
And so when something goes wrong, their first phone call is going to be to you as the agent. And so I think just having a good setup where you can follow, one of the first quickest, easiest ways to get yourself in trouble right from the start of the contract is the home inspection, right? Because it normally has to be done within 5-7 days. And then you've got, 2 or 3 days to negotiate. And if you don't get that home inspection done, the home inspection goes away. That contingency doesn't continue on like the financing might. It just goes away, and they don't have that ability to get out of the contract or ask for repairs. So, you've got to really stay on top of those things. So having a good checklist that you can go through, having a good way that you can actually, track those things, that will keep you out of a lot of trouble. So one of the easiest ways to get yourself in trouble is missing a deadline, mishandling funds. Now, the good thing is, when I started in the business, typically the buyer gave their earnest money to the buyer's brokerage, right? And they held that. That has become more and more a thing of the past, I think. It's funny, whenever I teach classes about that, I always, I would have people raise their hands and say, how many people have your broker hold the funds, buyer broker hold the funds? And when I first started, it was like everybody. And then I would say, well, how many people have the title company hold the funds? And it was almost nobody. And now that it's flipped on its head. It's almost everybody wants the title company to hold it. Nobody wants the buyer brokerage to hold the earnest money.
Why has that changed?
And I understand. Well, for the brokerage side, it goes back to liability, right? Because you have agents a lot of times that are taking the check from their client to bring to the office. Yeah. And, life happens. I can't tell you the number of times where people put the check in their purse, in their wallet, they're going to the office, and then the kid calls and they need to be picked up from school. And so now they're running to do that, and then they've got to take them to get them dinner, and next thing you know, it's 3 days later and they still have that check in their purse, right? And they haven't turned it in time. So you can, as an agent, get in trouble, and the brokerage may have a duty to report that you did that. So a lot of the brokerages, plus when it gets to the end and the parties are fighting over the earnest money, the brokerage doesn't want to hold the money and get in the middle of that. They'd much rather the title company do that. And just from a pure accounting standpoint, it makes sense for the title company to hold it because ultimately the funds have got to get to us anyway for settlement. So that, handling funds is always a way that you guys can get your, and this is where I'll do a little bit of a plug for the app that we use, which is called Zocam. And I heard people call it Zocam as well, but it's basically a way that your client, your buyer, instead of giving you the check to bring to us, because I usually recommend agents don't get involved in that, because that's when you mess up and you still have the check 3 days later, is, have them bring it to us, have them wire the funds to us, or use the app. And the app is so simple. Most people now have done some level of online banking. Even I have done this where, you get a check and you can just log into your account and you take a picture of the check and it deposits in your account. That's what this app does, essentially, is now they do have to have a check. So they've got to be able to, dig out a check from a box somewhere, write a check out to First Guardian Title for that earnest money amount. And then they download the app, they put in the property information, their information, they snap a picture of the check on their phone, but instead of depositing it in their account, it deposits in our account. So that gets them out of the middle. There's no liability there for that for them. And it will send an email out to the agents to let them know that the money has been deposited. So it's really just a great way to limit liability for agents and put it on the buyer to get the money to us. So very easy that. And then going back to one more thing that we talked about earlier is communication. One of the bigger complaints that DPOR gets about their agents is they never told me anything. They never communicated with me. And so even if you don't have you have that listing, and this hasn't happened much in the very recent past, but I've been doing this long enough that I remember when listings would sit for 6 months. And agents just wouldn't call their client. And so even if you just call them and say, hey, we only had one person go through this week, or we this or that, having that communication with them just takes away that liability for, oh, they never told me that was there. And then I will say the one last thing on that topic is, I feel like the old man that's like, oh, back in my day, right? It's just you used to sit down at the table with your buyer and you're the agent and you're going through the contract on paper and you're filling it out and you're talking through the contract as you're filling it out. But now what do most agents do? And I don't blame them for this. This is the way that it probably should be done at this point, is they fill it out and then they send it through some kind of dot loop or some kind of DocuSign type of thing, and then the client signs it on the other end. Well, what do they do? Anybody that's ever done any kind of electronic signing before, what do? You hit next initial, next initial, next initial, signature, next initial, signature, right? And you don't read it. And so I do recommend for new agents, have a conversation with your client, tell them what's in the contract. Especially new agents like to shy away from that because they're like, oh, I don't know the contract well enough. And we live in a Northern Virginia area where there's, it seems like 1 out of every 3 people I meet is an attorney. So people are just like afraid to, to have that conversation. And so I think it's so important to have that conversation. Tell them what's in the contract. Send them like a breakdown of, here's the highlights, the points of the contract. And then ultimately recommend to the client, like, hey, read this before you sign it. Because, even though, the agent might not be liable at the end of the day, the client's still going to look to them and kind of hold them responsible in their mind for that issue. Unfortunately for the agent, no matter what goes wrong, whether it's something along the lines for the loan, something along the lines for title, they always come back to the agent for that. So just communication and having a good team, whether it's People's Mortgage or First Guardian Title, making sure that you have a good team to work with.
And speaking on communication, what's the best way to document communication with clients to avoid any legal issues?
Well, I mean, so much of it now is text, and it still works. It's still in writing. Now, if you want them to have something that they're going to sign off on, if they're going to waive the home inspection, maybe you can sign something that says they understand the risks associated with that, and there are forms that they can sign for that. So I think that doesn't hurt to have something like that signed. In real estate, really, if it's not in writing, it didn't happen. But you got to be careful, make sure that you get your clients to sign everything. If you have a phone call with them that's about something that's kind of important, right? Maybe follow up with an email and say, hey, as per our phone conversation, this is what we talked about. Let me know if you have any further questions, type of thing. And just put that in writing so that you have that there to kind of cover yourself later on.
Yeah, make sure you check that little box. It says like notify when read or something.
Yeah, that's right. Yeah, track that they got it and they've opened it. Yeah, exactly.
And when in doubt, amend or addend.
Right. Yeah. And two, just pick up the phone. Hey, I sent you that. Did you get it? Type of thing. Can really benefit the agent.